Hello, my name is Brent Jacobson. I'd like to talk with you today about some important things you should consider before agreeing to sign on to a contract with an arbitration clause. These clauses often find their way into contracts, but parties give the practical effect of them little consideration and don't learn of the actual ramifications until a dispute arises. To understand arbitration clauses, one must first understand what arbitration is. Arbitration is what is commonly referred to as an alternative dispute resolution mechanism, in that it's an alternative to resolving disputes through litigation, where one goes to court and takes his or her case through trial to a judge or a jury. In arbitration, the parties agree to submit their disputes to a private system and have their case decided by either one or several private individuals who are commonly lawyers or former judges. If you are considering signing onto a contract with an arbitration clause, or including such a clause in your contracts, you should consider whether the clause will call for binding or non-binding arbitration. Binding arbitration means that the decision of the arbitrator or arbitrators is final. If you disagree with the result, you will not have the option of appealing it to a court unless there was some kind of fraud in the arbitration. You should also consider whether your arbitration clause requires all parties to consent to the arbitration or whether arbitration is required if either party demands it. If your arbitration clause makes arbitration binding and mandatory, you will have no choice but to take your claims arising under the contract with the other party to arbitration. In that case, you should understand the benefits and drawbacks of arbitration. Arbitration has the benefit of speed and informality. A typical lawsuit in court could take anywhere from 12 to 18 months to take through trial, depending on the congestion of the court. Arbitration, on the other hand, could be resolved in a matter of a few months. Some formal arbitration organizations also have fast-track procedures to choose from that require the arbitration to be completed in several weeks. Arbitrations also generally have little formality in terms of rules of evidence and procedure, thereby reducing costly and time-consuming motion practice. Arbitration also has its drawbacks. Pretrial discovery is often limited, making it difficult for the parties to learn what evidence may be in the other side's hands before going to trial. Arbitration is also costly. Filing fees alone can approach $10,000 for larger claims, as opposed to a flat fee of a few $100s to file a civil case. The arbitrator also charges by the hour in most cases, and rates of several $100s per hour are not abnormal. Judges, on the other hand, are paid by tax dollars and are free to the litigants. If you are contemplating signing a contract with an arbitration clause or including such a clause in your contracts, you should consult with an experienced lawyer first. I have experience with arbitrations on behalf of business clients under the rules of the American Arbitration Association and the Centers for Dispute Resolution, two formal arbitration associations, and would be happy to work with you.
For more information, call or visit us online. Anderson O'Brien, exceptional attorneys in your community.